Greetings aspirants, welcome to Narayana News. In today's daily news analysis, we have picked up certain important articles from the Hindu. The first article that I picked up is this passengers of Nicaragua flight based in Mumbai that has appeared in the first page of the Hindu. Second one is the fiscal deficit may breach 5.9% of GDP and narrowing trade deficit cut India's current account deficit to 1% of GDP in Q2. I have clubbed both of these articles to discuss in the form of what is referred to as a twin deficit dilemma. This is there in page number 1 as well as in page number 13. The third article that I have picked up is this 4 lakh contractual teachers made government employees in Bihar. This has appeared in the page number 12 of the Hindu, and this delves into some of the key issues related to contractual workers and for that matter even the gig and platform workers. The fourth issue that I picked up is this case of revanchism, where this has appeared in the Hindu on page number 10. The fifth issue and the final issue is India-Russia Inc. Key pacts related to Kudankulam nuclear power plant. This is appearing in the Hindu, page number 11. Coming to this article, passengers of Nicaragua flight whizzed in Mumbai. This article can be understood from the perspective of GS paper 2, where important international institutions, agencies and their mandate can be one area, or this can also be understood from effects of globalization of Indian society under GS paper 1 from the mains perspective. Look at this previous year question. Refugees should not be turned back to the country where they would face prosecution of or human right violation. Examine the statement with reference to ethical dimension being violated by the nation claiming to be democratic with open society. So the questions of migration is what it is being referred. What is the context in which we are looking at this issue? We know that an aircraft carrying certain Indian citizenry was detained in France and there were allegations of human trafficking. Second, after a particular delay, this is being allowed to fly to India, landing in Mumbai. What is the concern in this particular issue? The concern is twofold. The kind of migration that was occurring, if it were to be, is illegal, or on the other hand, the possibility is of the human trafficking. With respect to both of these, internationally, there is a standard. Even domestically, we follow this particular standard. One is referred to as the reported cases, and the other one is referred to as the registered cases. Whenever the illegality is involved, the international law and the domestic laws are being violated either with respect to the migration or with respect to the human trafficking. What we see is the number of registered cases are very small in comparison to the reported cases and the registered cases put together. It is this concern which is being considered by the media, because of which this is being reported. So in spite of the fact that this investigation is going on, this issue can be considered as significant from the examination point of view also. Migration, as we already know, has not been defined in fact internationally. However, there is a way in which it is being understood. The UN Migration Agency, International Organization for Migration, sees that whenever a resident of a particular nation is going to some other nation which is not his place of origin, this is referred to as the migration, wherein he might be moving here either for the purpose of finding some alternative employment or better employment or even otherwise. On the other hand, the UN Office on Drugs and Crime defines the human trafficking as either the recruitment or transportation or transfer or harboring or receipt of people through force or fraud or deception with the aim of exploiting them for the profit. So there is a profit motive involved, and also on the other hand, with respect to those which are being trafficked, there is a motive of exploiting them. It is this and the migration which are of concern in this particular case. As you see here, this particular chartered flight has been booked by some non-European entity, and the Indian people which are being the travelers of this particular chartered flight are from various states, Punjab, Haryana, Gujarat, for example, and this also includes, as we know, few minors. Alongside, when this has been considered in France, they have gone for what is referred to as legal proceedings, however, the details of which are yet not known. And we also know that the hotel tickets were booked in Nicaragua, and also return flight tickets were also be booked for the UAE. As we see in this particular issue, the concerns were there because of the fact that few of these passengers were seeking asylum in France itself, there itself. Second, there are also certain complicated legal and financial issues pertaining to these passengers because few of them were having a substantial chunk of money with them. Third, if you look at the diplomatic stance, both Nicaragua and UAE declined to host this aircraft, and hence Indian government had to urge the passengers to return. As you see here, we've already learned that there are certain reported cases, majority of chunk of such illegality involves such reported cases. On the other hand, there are very few registered cases. We see that for both of these, there are certain fundamental causes. One is the poverty and economic disparity that the third world has, particularly in India and Indian subcontinent. Second, there is demand for cheap labor, which the Indian labor actually provide. Third, there is also demand for sex workers from India, and we see this happening with respect to Nepal, with respect to Bangladesh, and many reported cases are there for last 2 months, as it has been pointed out by the global report that is published on trafficking in persons in 2022 by UN office, and the update also has been released with regard to this. And the third, we also see that with respect to either migration or with respect to human trafficking, there is a problem with regard to the enforcement of the law and the weak legal frameworks that are there. And fourth, wherever there is political instability, for example, in Nepal and Bangladesh, and also in some of the states in India where the enforcement is very, very weak, there you see this problem of human trafficking or illegal migration at higher levels. Alongside, there are certain other cultural and social factors which are also contributing to this phenomena, such as caste and gender. When you look at this global report on trafficking in persons reported in 2022, which has been published by UN Office on Drugs and Crime, it said that since 2003, when this UN trafficking protocol has been signed by many nations internationally, which has been brought into enforcement, it said that when it was a minimum at level of 0.9 as it is measured, it has reached the peak of 4.9 in 2022. As you see that these are all the registered cases which are being measured. Hence, the number which is being put also in the form of reported cases is very high as we see this particular report. In Indian scenario, and particularly this is applicable to all the low and middle income countries, as this report says, the informal and volatile labor markets and also politics over the issues of safe migration and orderly migration, it is leading to this situation of illegal migration and in some cases the human trafficking. Moreover, in spite of the fact that the politics over these issues of migration remain, profits have been globalized, as this report is pointing out. Given these concerns, what has to be done? Article 51 has categorically stated in simple terms that adherence to international law, practice of international law is the way forward for any particular nation, including India. Given this, being a signatory to the UN Human Rights Declaration and also as an economy which understands the significance of safe, orderly migration with respect to Indian citizenry, Indian government must take all the necessary steps to make sure that the migration and the safe as a way forward, adhering to the UN trafficking protocol and also adhering to the norms of laws of migration. is the way forward for India. Moving to the next article, we have clubbed this article of fiscal deficit and also the article that is dealing with the current account deficit such that we can discuss about what is referred to as this twin deficit concern. As you see in this particular news clipping, the fiscal deficit may breach the target set by the government, which is at 5.9%. On the other hand, the trade deficit is getting narrowed, because of which the current account deficit has been brought down to the level of 1% of GDP. We shall look into the article. There are concerns over the possible ballooning of the fiscal deficit and also narrowing current account deficit. It is this context that we are trying to discuss. You know what is fiscal deficit and current account deficit. We'll try to brush it up. If you look at the current account deficit, we know that there are three components. One, the trade in goods, which is called as merchandise trades, then trade in services, and also the transfer payments. As you see that the trade in goods and trade in services have been ballooning, and this has given a leverage to reduce the current account deficit to a narrower level. This is first aspect. Second aspect, if you look at much more basics of this, then we know that the calculation of size of the economy in terms of GDP involves certain methods. One of the methods is referred to as consumption method. You know that this consumption method includes the components of private consumption expenditure plus government consumption expenditure plus what is referred to as investment, which is also consumption, which is a future consumption, and then what is referred to as net exports, which also considered as the consumption. As you see in this particular method of measuring the size of the economy, which is referred to as consumption method, if you see that both of these private consumption expenditure and government consumption expenditure, they can be referred to as consumption put together. If you bring in this consumption to the left hand side, GDP minus consumption will be equal to investment plus this net export, as you see, is nothing but the current account balance. So this investment plus current account balance is what the equation that we will be arriving at. But as you see here, GDP minus consumption is nothing but what you have produced minus what you have consumed, which is what your savings is. Savings is equal to investment plus current account balance. As you see in this particular case, when you say that the current account deficit has come down, it means that savings minus investment is funding the current account balance, that is net exports. As much as the savings is going for the investment, the possibility of reducing the current account deficit is what we will see. This is what this equation is trying to convey. I repeat, when savings are largely being catered to the investment patterns, increasing investment rate in the Indian economy, it will lead to the favorable current account situation for the Indian economy in her relationship with external economy. Keeping this in mind, if you move forward, what about the fiscal deficit? As you know, fiscal deficit is nothing but the excess of government expenditure over government's income. When you know that the fiscal deficit is increasing, it means that the revenue income that the government is generating, either in the form of taxation or in the form of other income such as profits, or in the form of even the disinvestment proceeds, this income is insufficient to meet the current expenditures of the government, by which alone there will be ballooning of the fiscal deficit. What you see in this current scenario is that the ballooning of the fiscal deficit is occurring because of one particular fact, that there is increased expenditure towards certain priority areas. Government has prioritized the areas such as food, fertilizer, such that there will be more expenditure towards this subsidized expenditure. Hence, the ballooning of the fiscal deficit towards such revenue expenditure, ballooning of the fiscal deficit will occur because of the expenditure towards such subsidies. The government's increased expenditure towards such revenue expenditure, which is in fact the consumption by the government for the purpose of catering to the welfare requirements of some of the sections of the society, balloons, as you know, the fiscal deficit because there is more of expenditure over the income that it is being generating. On the other hand, yesterday we have seen in the newspapers that there is a gap between the disinvestment proceeds that the government has actually estimated and the disinvestment proceeds that the government might accrue for this particular financial year. This also adds to the increased stress over the fiscal deficit. Third, it is also said that apart from the current supplementary grants that the government is demanding from the legislature as part of Article 115, it is also estimated by the rating agencies that one more such demand for grant in the form of supplementary demand for grant might go towards the Parliament or the Lok Sabha for the approval. It is in this particular context they are estimating the ballooning of the fiscal deficit. Now, what is the problem with regard to this ballooning of the fiscal deficit? On the other hand, the narrowing of the current account deficit. As this ballooning will occur, what you see is the scenario of possibility of price instability. Whenever the price instability occurs, it will have its impact on the exchange rate. As it will have impact on the exchange rate, it will also have an impact on the both imports and exports. It is this which is causing a particular concern, wherein the current account deficit might also widen over time if this particular expenditure pattern continues. Until now, we felt that the capital expenditure by the government is what leading the scenario. However, the increased current expenditure might balloon the fiscal deficit. The second one, along with this, we also have the scenario of what is referred to as the crowding out of the private investments. Till now, government has actually led the capital expenditure, and time and again it has reiterated that it is expecting the private sector to now take the lead. In case of such increased fiscal deficit, which might lead to price instability, it might act as crowding out effect on the private investments. It is in this particular context, both of them are related. As you see that this situation of ballooning fiscal deficit might lead to price instability, and price instability might lead to inflationary concerns both from the food and fuel perspectives. This leading to the situation of crowding out effect on the private expenditure. As you see that it will have its impact on the current account deficit because much of the savings would also be going to such current expenditure or revenue expenditure of the government. On the other hand, we have a favorable scenario from the current account situation that Indian economy has. That favorable scenario is pertaining to the remittances. As you see in this particular picture, the remittances exceed even the overseas development assistance and foreign direct investment put together. It means that remittance, which is a form of transfer income, which is being transferred by the residents of India who have moved to some other particular economic territory and earning their real income in that particular economic territory by participating in some production process, are sending back some of the saved income towards their home economy. When this particular situation of higher remittances are seen within the Indian economy, particularly this is true with respect to low and middle income economies. It is to be remembered that in order to address this situation of current account deficit, and also in order to see that there is inward flow of investments in the form of these remittances, one must encourage what is referred to as safe and orderly migration of skilled labor. It is this which is leading to the scenario of higher remittances towards Indian economy. This is one favorable situation which has also brought down the current account deficit in the current scenario. As you see here, the way forward for the Indian economy pertaining to this relationship of the twin concerns over the twin deficit problem is that ultimately the macroeconomic stability must be ensured, wherein, as we have already debated, the crowding out effect on private sector must not occur. This will occur only when there is price instability, and hence price stability must be ensured, which is what had been the focus of the monetary policy. And until now, the price stability could be ensured in spite of the fact that there are certain concerns over the food inflation. This situation must persist such that the growth process of the Indian economy can continue. Moving to the next article, we look into these 4 lakh contractual teachers who have been given the status of being government employees in Bihar. This is significant from the GS2 mains point of view, particularly with regard to the schemes or welfare measures relating to the vulnerable sections and also the issues relating to development. Look at this previous year question. How globalization has led to the reduction of employment in the formal sector of the Indian economy is increased informalization detrimental to the development of the country. As you see in this question, the focus had been on the process of globalization and also how this globalization has been happening alongside the more and more informalization that is happening in the Indian economy. As you see in this question, and this issue of contractual employees being given the status of government employees, that to a huge number, this is significant. Hence, from the perspective of vulnerable sections, this can be a focal point by the examiner. As you already have seen, the context had been that the Bihar government has granted the status of government employees to 4 lakh contractual teachers. In order to secure this position, as the cabinet has decided, the contractual teachers are required to pass an examination. This is what it says. However, there are certain core issues in general with respect to labor and also with regard to what is referred to as contractual employment. With respect to labor, if you look at the outset, labor had been covered under the concurrent list. We know this. Because of this, we have a situation that the laws which are made in order to regulate and govern labor as an issue, labor as a subject matter, is made by both union and the state governments. However, post-liberalization, privatization, and globalization reforms, the government and the businesses in general have felt that the labor reforms is one particular pending issue because of which the growth is not actually reaching to its potential. And hence, the Second National Commission on Labor has recommended to remove the obsolete and archaic laws on labor and to come up with certain liberalized labor codes. It is in this context the union government has passed 4 particular codes with regard to the regulation of labor as an issue, and it is in this context we have to look at this particular regularization of contractual employees in spite of having a particular condition that they have to pass a recruitment test. Second thing, whenever a contractual employment is created, that means that there is a contract and this particular contract is based on an agreement. In general, this agreement will pertain to certain terms and conditions, and all these terms and conditions can be broadly categorized into 4 important principles. One is what sort of claims that one can have either from the labor or from the employer perspective. This can lead to very conflicting situation. We refer to these principles as rights. The second one, as much as you have rights, you also have what is referred to as duties. So if employer has a particular right, then the labor also has a particular duty towards this particular right. The third one is whenever the rights and duties are going beyond the perceptible levels of agreed conditions, this leads to a relationship which is referred to as the power relationship. And fourth, whenever such power relationship emerges, it leads to the conflicting position, and in this conflicting position, in general, one or the other will claim for what is referred to as immunities. It is 4 of these aspects which emerge as core conflicting situations between labor and employer. Since the colonial rule till date, all the contract employees have faced concerns with regard to 4 of these particular principles. All of those concerns can be grouped into 4 of these particular principles. Now, whenever a particular right is claimed, as you have already know, there is someone who has a particular duty. We know this. So, if employer is claiming a right, the labor has a particular duty towards this particular right. Similarly, if the labor is claiming a right, then employer has a particular duty. However, whenever there is a possibility of emergence of unequal relationship with regard to the rights that are claimed and the duties that have to be performed, then these duties to be performed can also translate into the privilege for the other particular member of this particular contractual agreement. That is, if labor's duty is pronounced, then in the case of this unequal relationship, it is the employer who will be claiming certain privileges. And at the same time, whenever there is a privilege, the other particular party cannot claim any kind of right. So you will have a situation where there is no right. Similarly, in this particular relationship of power, what you see is the power relationship will lead to a liability for the other party. In general, it would be the labor. As there is liability, then this liability will lead to the creation of what is called as immunity for the employer, and this immunity will turn as a disability for the laborer. It is these issues which are part of the labor-employer conflicts. It is 4 of these fundamental principles which the industrial relations between laborer and the employer is what we look to address. What about the new labor reforms pertaining to these particular requirements? The first such reform we have is the Code on Wages. What this Code on Wages has done is it has decided what is referred to as floor wage. Now, what is this floor wage? Based on the living conditions of particular labor in a particular area, depending upon the price level in that particular area, you have a particular living standard. So, based on that living standard, the employer must decide the minimum level of wage below which it cannot go. On the basis of this floor wage alone, the minimum wage will be decided. Now, in this particular respect, what is the concern with regard to either contractual employees or in general even the gig employees and platform employees? It is said that the wage inequality based on this particular provision must reduce by 10%, which is not the case as you see the PLFS survey. In fact, the wage inequality, as many reports have suggested, has widened. The second one is what you have is Industrial Relations Code. Before going to the Industrial Relations Code, we may also add one particular fact with regard to this Code on Wages. If you look at the gender gap with respect to wages, it said that this gender gap must be reduced by 6% in terms of what a wage that a particular gender gets and what a wage that the females are getting. Even in this particular respect, as PLFS suggests, this achievement of this particular target of reducing the gender gap has not been achieved. So the contractual workers, gig workers and platform workers pertaining to this particular target are still vulnerable. Second thing, the Industrial Relations Code that has been enacted is particularly relating to the regulation of what is referred to as trade unions. We know that the trade unions are important from what is referred to as the collective bargaining power. Individually, the labor might not have the bargaining power, but collectively, the entire labor group can have the bargaining power once they are organized. Trade unions are such an organized form of all the labor in a particular industry. Now, the trade unions, as you know, is to claim for their rights and duties. What you have seen in this particular Industrial Relations Code is this definition of trade unionization has been clearly watered down in such a way that the liberalization towards more investments can occur. So the focus had been on more of easing the businesses to pursue their business activities in India. On the other hand, in order to do this, as we see, the definition of trade union has been narrowed down. On the other hand, this also talks about regulation of conditions of service. Much of these regulations of conditions of service is pertaining to the issues from the beginning of recruitment to the extent of even the retrenchment of the employees, or including even the closure of the industry. Now, in this particular aspect of regulation of conditions of service, again, you would see that the employer had been given more of a weight in the form of a privilege, such that the employer can perform the business activity within Indian territory. The third, as you have the procedure and mechanism for investigation and settlement of industrial disputes. The erstwhile Industrial Disputes Act has been merged into this particular code on industrial relations, and this particular code refers to the industrial disputes in such a way that these can be settled on the basis of the agreements that have been signed between the contractual employees and the employer. Given this particular fact, as you clearly see, the ease of doing business has taken precedence and prevalence over the necessity of labor rights, given the fact that as we have more of unemployment situation in India, and as we have already learnt in our previous video, that this unemployment measurement is referring to the status of distress within the Indian economy. This liberalization had been seen as more important than the point of labor rights as against this situation. On the other hand, we also have this code on occupational safety, health and working conditions. Keep in mind that this defines two kinds of workers. One is workers in general, and the other one is the migrant workers. When you see that these workers in general have been defined particularly with regard to industries, whereas as against this, it also defines what is referred to as employees, and these employees are defined pertaining to not only industry but also any other form of such establishment which is manufacturing or producing any good or service. As we see this, the difference between worker and the employee, worker is subjected to the hire and fire mechanism. On the other hand, the employee can be subjected to the relatively organized wages, relatively organized forms of industrial relations. Third, we also see that in this occupational safety and health and working conditions code, the migrant workers have been defined. These migrant workers have been defined again under the definition of contractual workers, wherein a particular contractor may hire the migrant workers such that they can be placed in a particular establishment. What you see here is a limitation. If a particular contractor is hiring 20 employees, then the definition of migrant workers as contractual workers is applicable. It is in this sense, if you have employees below 20, then the applicability of this definition and the applicability of code itself will not be there, pertaining to more and more informalization in the Indian economy. So these particular codes are actually catering to the requirements of organized sector, leaving away the informal sector standalone, going through the same issues and problems that we have already discussed. On the other hand, you also have another code referred to as Social Security Code. The Social Security Code is referring to certain requirements in times of distress for the particular worker, including the death of such breadwinner. That might be pertaining to the maternity related benefits, that might be pertaining to sickness related benefits, or that might be pertaining to some injury happening to the contractual worker. In this particular code too, as you see that they have defined the contractual worker, including the migrant workers, wherein there is a limitation pertaining to the number. Below that particular number, if there is any occurrence of any of these particular events of uncertainty, then the financial recuperation that the Social Security Code will give will not be applicable. It is in this particular sense, those fundamental questions of rights, duties, privileges, and immunities still persist. Given the requirement of catering to more and more employment, given the requirement of the ease of doing business that the government is aiming at, much of these immunities and privileges are catering to the employer alone. The way forward for this particular issue is that unless and until these questions of rights, duties, privileges and immunities are not leading to the questions of liability and the question of disability. I repeat, unless and until these four issues are not leading to the questions of liability and disability from the perspective of the laborer, the ease of doing business for the current conditions of the Indian society and economy must be catered to such that more and more employment can be created within Indian economy such that this distress situation can be addressed. Moving to the next article, we'll discuss this issue of a case of revanchism. What's it all about? It's important from the GS2 Indian Constitution point of view, and it has certain intricacies with respect to the idea of secularism. If you look at this previous year question, how do the Indian debates on secularism differ from the debates in the West? The focus had been clearly on this principle of secularism in this particular context. What is the context in which we are discussing this issue? In 1991, a suit has been filed in Allahabad High Court, which has asked for a declaration from the court that would recognize a part of this mosque in Allahabad site as belonging to a particular Hindu deity. So the nature of religious worship and its change is what this particular suit is seeking. Second, court has declared that these suits in fact are not barred by the law. They can be entered. This means that according to the court, the suits filed in 1991 do not violate any existing legal provisions and can therefore be considered as legitimate. This has actually caused a furore over the concerns with regard to the idea of secularism and its implementation in India. There are two relevant laws apart from certain constitutional provisions that we already know. We know that the Constitution guarantees what is referred to as religious equality within fundamental rights. On the other hand, you also have secularism as a basic feature of the Constitution, wherein, as we define, secularism is all about all those activities we pursue within this particular territory, including those activities which are aimed at your life after death. So all the religious activities and spiritual activities that you perform are also part of this particular definition of secular or secularism. Given this definition, including the religious activities and spiritual activities, as we perform these activities in this territory alone, in spite of the fact that they are referring to some other particular life after death, we clearly see that all these activities are covered under the fundamental rights which are guaranteed by the Constitution. As you see this, there are two fundamental laws which govern these places of religious worship belonging to Islamic religion. One is the Waqf Act 1954 and the other one is the Places of Worship Act 1991. What are these particular laws about? The Waqf Act functions on the basis of four fundamental principles. From medieval India times, as we saw the prevalence of not only Islamic religion but also the Sufi tradition within Indian subcontinent, we saw that many of the people who profess Islam as a religion or cater to the Sufi tradition have sacrificed their properties, their lands in favor of certain charitable work or in favor of certain social use. It is in this particular context they have devised four of these principles to govern those or such properties. One principle is perpetuity, which means that once the particular land has been given this status of being waqf, by which it means that the nature of the property cannot be changed either by transfer or otherwise. I repeat, when we use the expression waqf, it means that this nature of the property cannot be changed by whatsoever means. Hence, perpetuity is that over generations, the nature of the land remained as the current definition, whatever has been given as waqf. When this particular land is catering to either charity or for certain social use, the community use, by which they have defined this particular land as to be owned by the god itself. Hence, the nature of the land can never be transferred or changed. Second, this is irrevocable. As you define this waqf land, this land remains as it is forever, and this particular principle of perpetuity remains irrevocable. Third, both of these perpetuity and irrevocability are unconditional in their nature. So there is no condition attached, there is no condition involved, and hence the nature of the property as waqf will continue forever. And fourth, as all these three are true, consequently, this land becomes inalienable, by which it means that you cannot change the nature of the property for any particular benefit or any particular use that is beneficial to a particular individual. It has to be purposefully for certain social use or the community use or for any charitable work. It is these principles which are subjected to certain modification. During the colonial rule, all these principles which are in vogue since the medieval times has been subjected to modification, given the fact that the colonial rule is looking to exploit as much revenue as possible from the Indian subcontinent. Hence, they have brought in the economic conceptualization within this particular lands. So what they said is the prevalence of the government's right over these lands can exist. As it can exist, these lands now can be decided by the government to have a particular nature in the form of economic use. So they said these lands can be used to raise revenue such that they can fund certain activities such as construction of bridges or laying of roads. This economic conceptualization has categorically violated all those four principles. Over time, this economic conceptualization has also led to the exercise of political control over these lands, clearly deviating from the fundamental objective of social use or the charitable purposes. This had been continued even in the post-independent India. So the Waqf Act, which has been passed in 1954, has said that the economic conceptualization can be there. For example, in any urban area, if that particular Waqf land is lying idle, then government can decide that this land can be used for any developmental purposes. So this economic conceptualization has continued, and consequently this has again led to the political control of such particular lands. It is this which in fact has reduced the nature of these particular lands to an economic one and the political one, whereby the fundamental objective of social use or the charitable use has been clearly compromised. Now, when you see that this on the one hand, on the other hand, this Places of Worship Act 1991, which has been enacted, which in fact is to make sure that the nature of the religious institutions, the places of religious worship, do not change their nature to some other character. From one particular religious character to another particular religious character has been enacted. However, this had certain limitations. This is applicable only to those places of religious worship which are there are considered after 1947, that is after 15th August 1947, after our independence. Second, this is not applicable to the Ancient Monuments and Archaeological Sites Act 1958, by which it means that there can be certain variation possible if a particular place of religious worship is defined under this particular law. Third, there is also an exception for a particular religious site in Ayodhya, and this exception has been provided irrespective of many other considerations. And fourth, most importantly, these exceptions which are driven by the court, we must also keep in mind that the particular law, that is the Places of Worship Act 1991, in fact bars any kind of judicial review. wherein the state can now intrude upon a particular place of religious worship and say that this characteristic can be changed because it is included in the Ancient Monuments and Archaeological Sites and Remains Act 1958. It is this issue which is also concerning pertaining to the current context of the ruling that has been given by the Allahabad High Court. So on the one hand, you have the principle of religious equality and the principle of secularism, which say that any activity can be regulated, however, it is subjected to certain reasonable restrictions. Both of these laws, as you see, have been diluted, and this dilution has led to the loss of what is referred to as public sphere for most of the religious minorities, as sociologists and political thinkers fear. Now, what is the way forward that is available? As we have fundamentally seen, the nature of the properties in the either form of work or in the form of the places of religious worship must not be subjected to any kind of transformation, such as economization of these properties, wherein, as against this, whenever such intervention happens, wherein the transformation of that nature of a particular property has happened, it must be restored. So the basic fundamental requirement pertaining to work land is that it has to be subjected to social use alone. There should not be any economization and political control at all. Second, the adherence to all those four principles must be ensured. And third, once we ensure these two, there will be a prevalence of public sphere, particularly for religious minorities, such that they can participate vibrantly in Indian democracy and its decision-making process. Moving to the next article, we'll discuss this issue of India-Russia signing the pact for future units of Kudankulam plant. This caters to the main syllabus from science and technology point of view, and also this can be covered under the defense cooperation that Russia and India have under the international relations. Look at this previous question. The function of heavy water in a nuclear reactor is to, in 2011, slow down the speed of neutrons, increase the speed of neutrons, cool down the reactor, and also stop the nuclear reaction. As we know that it acts as what is referred to as moderator, it is to slow down the speed of neutrons. What is the context in which we are looking into this issue? We know that India and Russia have signed this agreement relating to future power generating units at the Kudankulam nuclear power plant, which is there in Tamil Nadu. What is that very basic thing that we have to know? Remember that an atom has nucleus, and this nucleus, as we know, stores a lot of energy. This energy is referred to as nuclear energy. Where from this particular nuclear energy comes up? This nuclear energy is because of the inherent nuclear force that binds the subatomic particles called as protons and neutrons together within the nucleus. However, there are certain atoms which are referred to as unstable atoms, and these unstable atoms result into what is called as radioactivity. Any particular element which is above the atomic number 83 exhibits this characteristic of radioactivity. This radioactivity releases certain radiation into the atmosphere. This is called as alpha, beta, gamma radiation. And this radioactivity also refers to something called as half-life, meaning by nature, the nucleus of any unstable atom goes through what is referred to as decay, and whatever the time that it takes in order to go through this decay, whereby the nucleus becomes half of the earlier, it is referred to as half-life. So this is natural phenomena. On the other hand, there can be a controlled phenomena which we can use either to produce energy, which is referred to as civilian use, or we can also use this to produce what is referred to as weapons. There are two such fundamental types with regard to such production of nuclear energy or nuclear weapons. We stick to what is referred to as fission. Fission is one such nuclear reaction where an atomic nucleus splits, which is, as we already know, the unstable atom, it is whose nucleus which is being split. And as we know that this releases energy, and this energy is also accompanied by the neutrons and also smaller nuclei. What we see here is that whenever this fission reaction is being done in order to produce nuclear energy, as we see that there is large chunk of energy at a high level of heat is being released, we use two fundamental things. One is referred to as coolant and the other one is referred to as moderator. Coolant is to regulate the heat that is being released, and the moderator is to regulate the nuclei which hit these subatomic particles or nucleus, such that there will be release of energy through splitting that particular nucleus, which is the anthropogenic activity. So you have what is referred to as coolant and you also have what is referred to as moderator. As you know that this moderator in any particular nuclear reactor where such chain nuclear reaction occurs, it slows down the neutrons produced during the fission such that this chain reaction can be continuous. There can be many moderators, and the common moderators as we know, water, heavy water and also graphite. The Kudankulam nuclear plant, which is situated in Tamil Nadu, is the largest nuclear station in India. Already 1000 megawatt of power plant is being run there. Second, this harnesses fission energy of the uranium, and it is being built with the technical assistance from Russia. As you see this is the nuclear reactor which is referred to as pressurized water reactor. Here you are using water alone, that is the H2O, as both coolant and the moderator. Based on what type of coolant is being used and also based on what type of moderator is being used, there can be particular classification of the nuclear reactors. Based on coolants, you have these pressurized water reactors and also the boiling water reactors. On the other hand, on the basis of the moderator, you have the pressurized heavy water reactor or light water reactor. Along with both of these, you also have what is referred to as fast reactors. The Kudankulam nuclear plant is this type of pressurized water reactor. This pressurized water reactor, as we know, will have ordinary water as both coolant and moderator. There are two stages with respect to this cooling as an activity. The pressurized water reactors will have what is called as primary cooling unit, wherein the water flows through the core of the reactor at very high pressure, and hence the expression pressurized water reactor. Secondly, you have a secondary circuit which is present, wherein this goes to the turbine, and this steam is generated such that the turbine can be driven. So you have this primary and secondary cooling units. Moreover, you also have what is referred to as fuel assemblies, which contains what is referred to as the fuel rods, and these fuel rods will have what is referred to as the critical mass. Keep in mind that there are two fundamental requirements for this nuclear reactor to produce nuclear energy continuously. One is there must be involvement of this element having certain critical mass pertaining to these radioactive materials, and two, in order to have the chain reaction, there must be the presence of continuous supply of the neutrons. So the fuel assemblies, whatever you have, this will contain the fuel rods which are either uranium or plutonium or thorium, depending upon what type of reactor it is. Second, this pressurized water reactor technology is being learned from Russia and being implemented in India as part of this vibrant defense cooperation between India and Russia. When you see this defense cooperation, remember that this is symbol of long-lasting India and Russia friendship, and this is being continued and this will continue. Second, we also have the commitments under the Paris Agreement that we will have net zero of carbon emissions by 2070, and hence the nuclear energy is also going to play its role in the entire renewable energy footprint that we are going to have. Third, we know that this Kudankulam is still in the first stage of nuclear power program, where we have three-stage power program. The first one uses this natural uranium, second one uses the plutonium, and the third one uses the vast reserves that India has in the form of thorium. Now, this research must be improved, and this must also be subjected to certain timelines such that India reaches the third stage, whereby we reduce our dependence on foreign technology and also foreign supply of nuclear materials. Having completed the discussion over the articles, we'll now do few practice questions. The first question: consider the following statements regarding illegal human trafficking and the legal frameworks to address it, both internationally and in India. The first statement is the Palermo Protocol provides a definition of human trafficking that is globally recognized and emphasizes the need for a comprehensive approach to prevent, prosecute, and protect victims. The second one is the Immoral Traffic Prevention Act 1956 of India focuses exclusively on trafficking for sexual exploitation and does not address other forms of labor or exploitation, which is a false statement. The Protection of Children from Sexual Offences Act 2012 in India is an integral part of the country's legal framework against human trafficking, specifically protecting children from sexual exploitation, which is a significant aspect of trafficking, which is a right statement, and hence answer has to be 1 and 3 only. Moving to the second question. Consider the following statements. India became a secular nation after inserting the word secular in the Constitution through 42nd Amendment Act, which is a false statement. Right from the beginning, we had secular features. The Supreme Court ruled that secularism is a part of the basic structure doctrine in SR Bommai versus Union of India case in 1994, which is a right statement. The secular nature of the Indian state is secured by the Articles 25 to 28 of the Constitution under Fundamental Rights chapter, which is also a right statement, and hence answer has to be B. Moving to third question. Consider the following statements with respect to new labor codes. The contract labor is clearly defined in the new labor codes, which is a correct statement. The second one is principal employee is liable to pay wages to contract laborer in case of default by the contractor. Which of the above given statements are correct? As we know, first statement is correct, the second statement is false, and hence answer has to be A. Moving to the fourth question. Consider the following statements. The pressurized water reactors use heavy water as moderator, which is not right. PWRs are fusion-based reactors using uranium rods as fuel, which is also not right. It is a fission-based reactor. Which of the statements given above are correct? As we know, neither one nor two. Moving to the fifth question. Consider the following statements. The estimated target of fiscal deficit of Indian economy for 2023-2024 financial year is 6% of the GDP, which is a false statement. India has experienced current account surplus for first 2 quarters in the 2023-2024 financial year, which is also a false statement, and hence answer has to be D. Moving to now one mains practice question. Take this question. What do you understand by twin deficit dilemma? What impact that it can have on macroeconomic stability of Indian economy? You will introduce this answer by defining what is fiscal deficit and also what is current account deficit. Then you can write about the dynamics related to the twin deficit dilemma. Apart from that, in body, whatever the mutual dynamics for current account deficit and the fiscal deficit that we have discussed, that can be introduced too. In conclusion, you can write by saying that the macroeconomic stability is not just a condition that is required, but it is a prerequisite in order to have a very sustained and rapid economic growth in Indian economy. With this, we have concluded this session. Please like, share and comment on this video, and also don't forget to subscribe to our channel. Thank you one and all.